What was the rationale for it? What was the justification to reduce it from 72 hours to 48 hours? As far as I know, as far as my engagement with law enforcement is concerned, the police have been struggling with the 72 hours. It can be too short for you to gather evidence against an alleged criminal or alleged culprit to put them before a court of law for remand. So what happens is that within 48 hours, you don't have enough evidence. You have to release that person back to go back to the society and commit more crime. Therefore, I think that has to be a decision that has to be really revisited. 48 hours is too small. Yeah. So, I mean, why change it in the first place? That should be my question. Why change it in the first place? 72 hours has been working fine.
So one can conclude that the decision of cabinet to revise the 48 to 72 hours in accordance with the draft constitution was informed by maybe, you know, was inspired by what you received as part of the consultation from the security sector.
I'm not speaking for, I will not be justifying for cabinet here. I'm speaking here as what I see things. I mean, some of these are technically legal, and I think the Minister of Justice now is coming with a press conference soon. He'll go into those details. What I'm saying, broadly speaking, at a general level, is that why change it from 72 to 48 hours in the first place? If the 1990 Constitution that has been working for many years is 72 hours, and the police are even saying that that's even tight, why bring it to 48 hours, causing more problems?
We move on now because we have more areas to touch on. Viewers, for those of you who are just following us right now, you are watching the Gambia Radio and Television Services, and with me in the studios today is Dr. Ismail Ceesay, the Minister of Information, and we are discussing the constitutional building process of the country. Some of you are aware that the draft constitution has been regazetted by government, and some months to come will be introduced in Parliament. But of course, when it was regazetted, people have had the access to review the document, but they also have raised some concerns, sparking debate. Now we have the Information Minister to clarify on some of these talking points, so long as the public opinion is concerned. Now we move on. Chapter 5 of the draft constitution, 2020 draft constitution. Here we have two draft constitution here. The draft and the redrafted constitution. Chapter 5, 2020 draft constitution provided guidance on good governance, you know, and good governance defining, you know, the principles of leadership and all of that. But it has been removed. It has been totally deleted from the draft constitution. It's not in the refined one. What led to this decision by cabinet, and how will the principles of good governance be addressed in this new redrafted constitution?
Well, you see, constitution building is a very rare enterprise. The constitution is not supposed to be very detailed, legislatively speaking. The constitution always, anywhere in the world, just lays the framework for governance. Now, you don't put issues of integrity in public office in a constitution. There's nowhere in the world, there is no serious constitution in the world, in the biggest democracies, in the most entering democracies, that deals with issues of integrity in public office in a constitution.
But good governance is not integrity.
No, this chapter is integrity.
Integrity.
It's integrity in public office. And issues of integrity are subjective. You cannot get any Supreme Court in the world to interpret issues of integrity. These things should be left for subsidiary legislation, let's say in the GOs or in the public service instruments, but not in a constitution. It's going to cause more problems than it's going to solve problems. So therefore, I think that was the part of the reason. Like I said, the Minister of Justice will go into detail as to cabinet decisions after that. I don't want to preempt it. But broadly speaking, my understanding is that anybody who understands constitution building process, you know that issues of integrity, issues that are subjective in nature, you don't put them in a constitution, but it causes problems. It's very difficult for any Supreme Court to interpret when there's an issue. So for me, I think it was a very wise decision for the government, for the cabinet to remove that entire chapter, because it doesn't make sense. It doesn't fit in a constitution.
Now we move on. We will look at the freedom of assembly of course, which I hinted earlier on. In the 2020 draft constitution, we've seen that, it said the freedom of assembly shall be exercised subject to the law of the Gambia insofar as that law imposes reasonable restriction on the exercise of the rights and freedoms thereby conferred, which are necessary in a democratic society and are required in the interest of sovereignty and integrity of the Gambia, national security, public order, decency, or morality, or in relation to contempt. This is what the redrafted constitution is saying. But when you look at in the CRC draft, it guaranteed, the freedom of movement, but not setting, some kind of limitations. How would you explain this to the public as part of government,
the freedom of movement or assembly?
Freedom of assembly.
Assembly. I mean,
freedom
obviously, listen, that was another fundamental flaw by the. You cannot give freedom of assembly unrestricted in a democratic society, which has a fragile democracy. Remember, it's a new democracy, and even in strong entrenched democracies, people still need permit to really assemble, especially to demonstrate. Now, the purpose of the permit is not to restrict people from assembly, it's to protect them. Because obviously, the right you have to protest for a particular cause is the right other group has to counter-protest against a particular cause. And for the police to be able to do an assessment of the security situation at a particular point in time and protect the public's interest in terms of property and persons, the police must be able to get prior notice that a particular group or groups want to do a peaceful protest or want to assemble. So they can do the necessary assessment and give you necessary security you need to protect life and property. So for me, I think, yes, people have a freedom. They have a freedom to assemble, but at the same time, this freedom of assembly must not be curtailed arbitrarily, but must be controlled in a manner to ensure that the public's interest is protected when it comes to life and property. And also, the security and the protection of those who want to assemble is also guaranteed by the police by making sure that necessary deployment is done to protect and so ensure that their safety is guaranteed. So this is normal in a democracy.
But some members of the public, of course, the concern is that the police is part of the executive. Of course, it is out of goodwill to, to seek permit and be offered security. But there are some instances that the police would use that, of course, at the whims and caprices of the, the executive against the opposition, to exercise their fundamental right to freedom of assembly.
But that thinking goes against what has been obtaining in the past couple of years since President Barrow came to power. This Gambia police force has issued more permits to people to protest than Gambia has done since this law was passed. And most of this is given to, in fact, to the opposition. Recently, you saw the opposition came out, they want to protest against corruption, they were given a permit, and they marched until to the National Assembly. So, since President Barrow came to power, there has not been such an instance where the police willfully, out of whims and caprices, deprived people the permit, knowing fully well that giving them a permit would not cause any serious breaches of the security. So for that, we don't have an issue with that. The most important thing, a police must be notified of any protest or public assembly which borders on public safety and national security. The police must do an assessment of the situation and ensure two things. One, they provide the necessary deployment to ensure life and property are protected from the general public, people who have nothing to do with the protest, but also those protesting protagonists are also protected and their safety is guaranteed from counter-protesters. So the police should be a big, yes, there's freedom of assembly, but this must also be controlled in a manner which is in line with the public's interest.
We move on. We have a limited time. I'm being signaled right now. Another major concern expressed by some groups of people, but of course, who are also part of members of the public, is about the education, bit of it. The 2020 draft constitution guaranteed freedom of, guaranteed full access to basic and secondary education, free access to basic and secondary education. Some are surprised that in the drafted constitution that has been now limited to only basic education. Why the change?
Again, like I said, constitutions are supposed to be providing frameworks for governance. There are some rights. If you put them in a constitution, you put yourself in a serious situation. Now, if you know, as a country, as a government, a particular right cannot be guaranteed because of resource constraint, and you put that in a constitution, you open yourself for litigation. Now, if you put in a constitution that higher education should be free in the Gambia, but you don't have the wherewithal to provide that money, how much will it cost to say that secondary education is free? How much will it cost the government? Where will the money come from? And you cannot provide it. You open yourself for litigation. People can take the everyday people are going to take the government to the courts to say that, well, the government is violating the constitution because the constitution promises and guarantees this particular freedom and the government is not doing it. So the government must be smart and understand what is possible in the foreseeable future.
But now we have freedom of, now we have free access to basic and secondary education. But has there been any instances that government has failed in that regard to an extent that people are, taking up litigative measures against the government?
No, but you remember, like I said, when we build a constitution, we don't think of what's happening today.
Yes.
We think of tomorrow. Gambia will come and usher in a society with a very strong civil society, with a very strong democratic community, with a very strong middle class that will take the government to court and hold the government to task. If we're not doing it today, doesn't mean that we'll not do it tomorrow. So government has to be smart and have foresight and be visionary to say that this could cause problems along the way. And now, even though it's not in the constitution, that doesn't mean that government cannot do it. It doesn't have to be in a constitution for the government not to do it. Right now, government is providing free education, basic and secondary, if I'm not mistaken. But it has to be, if you put it in the constitution, it means that it is incumbent, you must do it.
That is exactly what the constitution has done by saying that basic education is free.
Yes, it is free.
Now.
Yes.
But in the future, it could also be challenging for government.
Yeah, but government has done their calculations and know that that one can be guaranteed. What cannot be guaranteed is secondary. And that one which cannot be guaranteed can be put in the constitution, because otherwise you open yourself for litigation from the public. And you don't want a government to be always distracted by such litigations.
Thank you very much, the Honorable Minister. Viewers, those of you who are watching us, I've been talking to the Minister of Information on the redrafted constitution, which has also been gazetted by government and yet to be introduced to Parliament in some few months to come. Now we will move on, Honorable Minister, because we've got not much time here. Now let's go on decentralization of government. We have central and local governments. When you look at the 2020 draft constitution, has addressed the issues of decentralization of government. Both the 2020 and the drafted one have somewhat agreed on the need for decentralization. But there is one bit that is missing, that has been deleted from the 2020 draft. And that is section 206, subsection 3 of the 2020 draft, which has been removed, which is no person or authority shall interfere with or compromise a local government authority's exercise of its powers or ability or right to perform its functions under this constitution or act of the National Assembly. Why was it removed?
Look, I mean, it's like I said again, the CRC was haunted by Jammeh's ghost. I commend them. I think they did a fantastic job. But what obtains in Kenya and other countries, and I've seen that they've really drawn inspiration from the Kenyan constitution whilst we are drafting this constitution. Gambia is a centralized state. Decentralization is to ensure that government serves the public, serves citizens at the decentralized level. And government cannot be everywhere. So therefore, you need local governments to be able to provide some of the basic amenities to the people. However, decentralization doesn't mean usurpation. You cannot have micro-states within a state. You cannot have a state within a state. You cannot take powers away from the central government and give it to the local governance structures and say they should be working in a manner in which the central government has no say over the local government. That will cause anarchy in any polity. So therefore, I don't think it was a wise decision.
So the executive wants to interfere?
Not interfere. Not interfere.
So why was that section removed?
No. But what is interference? The executive must have control over the local governance structures.
Control.
Because they are here to serve the public. We can have only one sovereign authority in a state. Sovereignty cannot be, we don't have a federal system where sovereignty is shared between the center and the periphery. We have a centralized state system where the central state has the authority and the sovereignty to decide what happens in a particular territorial jurisdiction.
But devolution of powers is what we have seen in many democracies in the world.
We don't have devolution in Gambia. What we have is decentralization, where government gives some authority to local governments to do some particular job.
So it's a delegated responsibility?
Kind of. But it's not, we don't have a devolution like we have in the UK, where Scotland have their own devolved parliament, where Ireland have their own devolved parliament. We don't have a federal system like in Nigeria. We have a centralized state, a state that has absolute, unquestioned authority.
But that is not codified. That is not codified anywhere.
But it's in the constitution. Gambia is not a
centralized state.
Of course, Gambia is not a federal system. It's not a devolved system. Gambia is a central state. All power resides with the state. That is why the local governments cannot engage in foreign policy. They cannot have their own army. They cannot have their own police.
Powers of both the executive and the local
any power given to the local government authorities is given to them by the state, the central state, in exercise of its powers within the jurisdiction of the Gambian territory. So therefore, you cannot create a system where you say the local government must act separately. That is creating a state within a state, micro states within a state that can cause, that can precipitate anarchy in this country. So whereby you have a particular council saying, that we are going to act in our own way because we have our own powers. Then where is the state then? You cannot accept that in any country. No democratic country does that.
Yes. If you look at the 2020 draft and the revised draft, what is spelled out is that it shall be an object of the local government system that so far as possible, issues of local policy and administration shall be decided at local level, and the local government authorities shall cooperate with central government in adopting, a policy.
Exactly. So, cooperation. Cooperation is what is needed. They cannot be usurping the powers of the central state. They cannot be sovereign state within a state. That is not possible. So when you create a system like that, it causes problem. Like I said, if this 2020 draft of the CRC was allowed to pass in the first instance, it would have caused us a serious constitutional crisis in this country along the way.
But the draft says that both the central and the local government should adopt a policy of decentralization.
Of course, that policy should be put in place, and that's in the Act. Mostly it's in the Act. The Local Government Act will now define the relationship and the parameters of the powers of the local government, and also with its relationship with the central government. All these things are clearly spelled out in the Local Government Act.
Yes. In the revised draft, in contrast with the 2020 draft, which requires the judiciary to submit its budget through the executive. The opposite was spelled out in the draft constitution. Because the judiciary is an independent institution, its budget has to go straight to the National Assembly instead of going through the executive. Why?
But who makes the budget? Who makes the budget? Who prepares the budget?
It's formulated by the executive.
Exactly. So the executive must be able to know whether a particular budget is sustainable or not. It's not to kind of derail any institution or to undermine the powers of any institution. But remember, the executive, like I said, is the one who makes and prepares the budget. So any budget that should go to the National Assembly is sometimes important for executive scrutiny.
could that not be subject to abuse? Maybe the current government has goodwill, it was well-intentioned development, but we are making a constitution, for the future. Would it not be abused?
But who makes the decision for the budget? It's the National Assembly at the end of the day. Passing it through the executive doesn't mean that they make the decision. It's just that they want to have scrutiny over what budget is going to the National Assembly to see whether it's sustainable or not. Because the executive is responsible for getting the money from somewhere. They bring the money and they allocate the resources in confirmation with the National Assembly. So therefore, as you know, nothing wrong with, I think people are blowing these things out of proportion. I mean, it's good for it to go to the executive to see whether a particular budget is sustainable or not, and whether we can finance it or not, if it goes to the National Assembly.
The executive, of course, may not be happy with some decisions by the judiciary. Of course, we've seen some, some cases that have been brought before the court, and the court, of course, judgments coming out against the executive, but also against, some members of the public. Who knows? Maybe in the future that could be subject to abuse.
No, I don't think so.
That is, of course, that's the argument.
I mean, this is best practice. A standard practice that the executive scrutinizes the budget of all the institutions in the country, because they're the ones who generate the resources and allocate the resources in line with what is sustainable. So therefore, nothing is wrong with that. I think people have to understand that.
Basically, everything will have to go to Parliament, and Parliament will have to...
No, of course, at the end of the day, it's not the executive that decides that votes on the budget. It goes to Parliament. Parliament is the one who makes the final decision.
But what goes to Parliament is what passed through the executive.
Exactly. So it has to pass through the executive.
If I needed $100, and I submitted it to you, and you find it unjustifiable or unreasonable.
If all other budgets, all other institutions, their budget go to cabinet before it goes to assembly, why should the judicial not go to the executive?
Because it's an independent institution, and they wouldn't want the executive to interfere.
Oh, but you see, I don't think by routing it through the executive really is interference. It's for the purpose of scrutiny and to ensure that what they call budget sustainability.
Now let's move on. The CRC draft included a requirement for political parties to disclose their source of fundings during nominations. This requirement has been removed from the new draft. Why was it removed?
Well, this can be debated, but I think if the government is not financing political parties, they should have little say in how they get their finances, especially in our democratic setting. Some things will just cause problems. I mean, government doesn't give political parties any financing. So, I mean, this is something that is debatable. If it goes to Parliament, political parties are represented there, let them debate it there. If they think that it's not good practice, they can decide. But based on my own understanding, is that in most countries where political parties are funded by the state, if political parties give you funding, now they can be able to scrutinize your income. But political parties don't get funding, and you want to know where they get the money from, and that can be problematic. How do you really, the nature in which we fund political parties are through crowdfunding, people giving particular donations. I mean, it's going to cause more problems than it's going to solve the problem. So for me, to be honest, let's debate this along the way and see what is.
That argument could be challenged. That let's say that is what is called asset declaration. Now, even though government does not give you the properties you own, you didn't get the properties from government. You work for it. You earn it. It was given to you, or you work for it. But you have to declare this to the IEC. If you want to work for the government, if you want to work for the government, you are contesting for public office, and you want to go, you want to work for government.
If you are contest for public office and you win, you have to declare assets, isn't it? But in this case, it's a different thing. These are political parties that are registered as political parties. Yes, perhaps it's important for us to know their source of income, but should it be a matter of the constitution? That should be perhaps in the electoral laws. that political parties must declare their access to the IEC. I don't think it should be an issue of the Constitution again. Like I said, we are overflowing this Constitution with issues that should be left to subsidiary laws.
Now let's move to the final question here. We've got no time. In just a few seconds, you explain this. The revised drafts specified asset declaration for the Vice President and ministers, and it did not include their spouses and children, but the draft 2020 draft did. But
are their spouses and their children employed by the state? I mean, that doesn't make sense. How can you force someone to declare their assets and you have not employed them? I am the one who is employed. I should declare my assets before I start office and when I'm about to leave. But why should I have to subject my family to an assets declaration when they're not employed by the state? So obviously, that should not even be an argument. That's a no-brainer.
Honorable Minister, thank you very much for coming to GRTS and explaining about government's position on the revised draft constitution. But I understand that this content is also simultaneously broadcast on some other national televisions. It's always a pleasure. Thank you very much for joining us, viewers. This was a special program, and I was joined by the Honorable Minister of Information, clarifying on some issues of concerns that the public raised on the revised 2020 constitution. Thank you very much for joining us. Until next time, bye-bye.